So this is different then to making a will, because obviously a will is something that most people are already familiar with. I'm already familiar with. How is this different? Like, what else is there to think about?
Yeah, so wills are great. They provide instructions about how you want to distribute your assets after you've gone. These can be personal assets, jewellery, keepsakes, items of sentimental value, not just real estate and shares if you're lucky enough to have them. While it can be uncomfortable or difficult to talk about or document a will, and one study some years ago noted that only about 47% of Australian adults actually have a will. Talk about death-denying society. Sorry, but our mortality rate, despite all modern medicine and healthcare has to offer, is still 100%. There's no escaping it. So we need to get our heads around this. We're not going to be here forever. But once your will is done, that's great. You can move on with your life. But that's about after you've gone. The other side of wills, or lack thereof, and what we don't like to think about too much, is about that period leading up to our death, which might be over a short period of time or a lengthy period, depending on whether we die suddenly or our death is somewhat expected. Many people aren't too worried about that sudden death because it's out of our control. And in my experience, people are more concerned about the gradual decline or loss of thinking abilities and being able to speak up for themselves. And they wish to maintain that sense of self and have some control over what happens to them when they can't speak for themselves. And hopefully this wish for control isn't out of fear, for we all have times in our lives when we're more vulnerable or dependent on others. That's life really. The wish for control is more about giving others, providing our care, some insight into who we are as a person. So in the lead up to our death, regardless of when it comes, tomorrow or many years away, it's useful to have a few other things in place that can best represent us as individuals within our human society. And so in terms of thinking ahead, it might be, if people need to think about, or it helps if you can think about that time when you might not be able to speak for yourself. As I mentioned, it might be, sudden or very gradual. It might be the result over a gradual decline over a period of time due to, with having a condition that might affect your memory or thinking abilities. So, and this situation could arise for any of us at any time. So if something happened tomorrow, such as a major accident, it would assist the health professionals treating you to know what's important to you. Obviously, with major incidents, the health system swings right into gear to try and cure the catastrophic event and minimise any potential damage to our bodies and get us back to how we were functioning prior to the accident. And that might include state-of-the-art machinery for investigations and treatment, surgery, rehabilitation, all kinds of therapy and drugs, everything possible. That's our quest, to fix you up and get you back on with your life no matter what it takes. But sometimes full recovery doesn't happen. It doesn't mean we don't try. If that happened to you, the medical team would talk to you about what options you have and what's available. What sort of treatment options you have. But what if you don't understand what's being said? They'd need to find someone who can represent or represent you and they can get an idea, but we need to know, are we talking to the person you would want? Often it's just the person who might be standing by the bedside or visiting. So is that the person you want representing you and speaking on your behalf? So thinking about who you would want to make decisions if you couldn't do this for yourself is the first important step. Appointing someone to make your health and lifestyle decisions is called something different in every state in Australia. For instance, in New South Wales, where I work here at Randwick, the person you appoint is called an enduring guardian. And, I think sort of there's a bit of a difference between guardians and power of attorney. Ruth, you might have heard of power of attorney and enduring power of attorney. Do you understand the difference between power of attorney and enduring power of attorney and enduring guardianship?
No, I have to confess I don't.
Oh, well, I'll go on to explain these things. So what I'm saying here is basically public information, but please seek legal advice in regard to your own affairs.
Of
Power of
course.
attorney is a legal instrument that you, the principal, appoint someone you trust, the attorney, to manage your financial affairs, such as real estate, shares and money matters. There's a clause in the appointment in New South Wales that notes, and this appointment will continue in the event that I lose capacity. So if this clause remains in the appointment, it's not deleted, then the appointment is described as an enduring power of attorney. So they can manage your finances and real estate and things right up until your death. Trust regarding these matters is very important. So please seek legal advice from your family solicitor or community legal centre. I'll leave some information regarding this for you, Ruth, on the feed that you can put on the website for people
Thank
to
you.
read. The enduring power of attorney appointment, that helps with someone managing your financial affairs when you can no longer do that for yourself. But that appointment doesn't necessarily give that person the authority to make health and lifestyle decisions. So, you know, who can make those decisions if you can't do that? So if you can't make those decisions for yourself, in some states that power of attorney might include a medical power of attorney, but in New South Wales it's a different appointment. If you want someone in particular to act on your behalf in relation to your personal health and lifestyle decisions, that person is called an enduring guardian. So enduring guardianship in New South Wales is a legal appointment where you can appoint one or more people with specific functions, and they can make decisions about certain areas of your life. And you might appoint a primary and an alternative guardian, or you might appoint a couple of people to make decisions together or separately in regard to your decisions. You can add limitations or directions into that appointment. And a prevalence study found that, a national prevalence study found that in Australia, about 27% of people who had appointed someone as their enduring guardian had actually put directions into that appointment. So it's important that we, as health professionals, if we can get a copy of that. But in terms of doing that appointment, you sign it, the guardian signs it. Now, those signatures need to be witnessed by an eligible witness who's an Australian legal practitioner, like a registrar of the court, local solicitor, an overseas legal practitioner, or an approved officer from New South Wales Trustee and Guardian. There are some things that a guardian can't do. You'll be glad to know that they can't make a will or alter one on your behalf. They can't vote or consent to marriage on your behalf. They can't override your objection to treatment, and they can't consent to special treatment. And that's classified by the Guardianship Act, what special treatment is. I won't go into that here. In those circumstances, if the treating doctor thought that the person actually needed special treatment, they would need to go to the Guardianship Division of New South Wales Civil Administration Tribunal to get consent for that treatment. And they'd need to show good cause as to why that would be the best option for the patient. And guardians can't make decisions that are contrary to the law. So as I mentioned before, enduring guardianship is a legal appointment, so seek legal advice. So that's, you know, power of attorney, that sums up the legal appointments. You've got enduring power of attorney and enduring guardianship. Those appointments, they can kick in and they can help you make decisions when you can't do that for yourself. That's a good mechanism so that we don't all end up in tribunals trying to get people appointed. So unfortunately, not everyone has someone they want to appoint to make those important decisions, or they want to provide their enduring guardian with some sort of further advice about their wishes. The next option after those appointments is to think about discussing your wishes and possibly developing an advance care directive. You don't need a solicitor for this, but you might like to involve your local doctor or a health professional you trust to assist you. You might wish to involve your family or friends, but not everyone does. Some older people often sense their adult children are a bit uncomfortable about having these discussions, so they start the process themselves. An Advance Care Directive is a document you complete that advises of treatments you would or would not want if you're unable to speak for yourself. They're very personal documents that tell us as health professionals what's important to you. sorry. They usually include a description of an irreversible situation. So you always get treated. It's not about today when you're well and, you know, you need something to just get fixed. It's when you're at an irreversible situation that would be personally unbearable to you, whether that's around your physical abilities, your senses, your thinking, or social abilities, and you can't speak for yourself because you're so unwell, you can't understand the options, or you're unable to communicate them by any means. Should you reach that situation, and it is, you know, after tests and investigations considered to be irreversible, then you outline what your goals of care and treatment might be. And, you know, are they to focus on comfort rather than cure? And if that's the case, your underlying medical condition, if that is irreversible, the doctors would align the treatments provided in accordance with your wishes. Mind you, not everyone wants to do an Advance Care Directive, and not everyone wants to refuse medical, you know, certain medical treatments. For some people, they believe, you know, it's important to do everything to sustain life, no matter what. It's important to know that that's what the patient wants either way. So having this written actually assists us. It's not just about saying no to things, it's about saying yes to who you are as a person and what's important. However, while the treating doctors, the treating doctor has the responsibility of determining what appropriate treatment to offer that provides the best chance for the patient according to the goals of care, they're under no obligation to offer a treatment that won't benefit a patient. Our goal is to promote health and well-being, and not to prolong someone's experience of dying. There's no legislation or specific form for Advance Care Directives in New South Wales. Some states have, you know, legislated Advance Care Directives. In New South Wales, a valid Advance Care Directive is recognised under common law, and a few have been tested in the court system. In New South Wales, we've got a New South Wales Health Consent Manual that we follow, and it states that an Advance Care Directive will be valid when there's 3 conditions. It's been voluntarily completed by an adult with capacity, it's clear and unambiguous, and it was intended to apply to the situation at hand. In our district, we recently trialled and evaluated a document called Making an Advance Care Directive, developed by New South Wales Health. And I'll provide web links at the end if you want to access this document. It provides information and a form at the back of the booklet. I recommend that you seek the support of a health professional when developing an Advance Care Directive. But you can write your Advance Care Directive using any format you like. This is just one tool available. You can write it as a letter, you can write it whichever way you like. And some people may not want to write a directive. They might want to be that bossy. They might just want to document a plan or give a bit of guidance to others. They're not too fussed about being specific. We call that an Advance Care Plan. And Advance Care Plans provide guidance, just gives us a little bit of an idea about what direction to go in, about what's important.
Can I summarise my understanding so far to check that I've got it right? So obviously will's something that's happening only after death.
Yeah.
Everything else is pre-death. Sooner is better than later, because what's wrong with starting now to think about what you want?
Yep.
Power of attorney is very much the financial side, managing financial affairs if you're unable to do so yourself, but it's not related to health.
That's correct, yes.
And then enduring guardianship is health related and legally binding.
That's right. Because it's a legal appointment, it tells us as health professionals who we need to get consent from, and depending what functions that guardian is given. So they might be given accommodation, so they can decide where you live, what services you receive, what healthcare services you receive. That's an important function to have when it comes to making end-of-life decisions. You need to be a guardian to make those decisions on behalf of someone. They can determine what community services can come in to assist you, those kind of things. So yes, guardians have particular functions. And if people don't have a guardian, they haven't done enduring guardianship, if later on we needed to go to the guardianship division of NCAT to seek someone to be appointed, they might appoint the public guardian or appoint, a family member as a private guardian, and they would give them functions around what was required for the situation at hand.
And alongside that, you also have Advance Care Directives and Advance Care Plans.
Mm-hmm.
And obviously the legislation differs by state. So obviously everyone needs to check their own state for and it changes over time as well. But at the moment they in New South Wales, they're not legally binding. Is that correct?
No, well, because we haven't got legislation, we can't say the law says this is how you have to complete an advanced care directive.
But they're recognised.
Yeah, they're recognised under the common law, which is basically the courts have ruled. So we have had 2 cases that I'm aware of where health services have taken a patient's documented wishes to the New South Wales Supreme Court, for instance, to say, should we be following this? Should we follow this direction? And the courts have upheld it because it met those validity requirements. So it was recognised under common law. But there's a lot of history in common law that judges that, guides that. But I'm not a legal expert, I need to say.
Sorry. And both of those as well are very much about specific health related decisions. So, if I find myself in a position where something is irreversible, this is about my opportunity to have my wishes pre-stated.
That's right. That's correct. And it can be very different for everybody. So
sure,
it's not a one size fits all kind of thing. Some people just prefer to work through a few scenarios and think through things themselves and write up a Word document or a bit of a letter. And so it's more around the intent of the document, regardless of what the heading on it says, whether it's a plan or it's a directive. If people say, I want this to guide decision making, this is what's important to me, that helps. That gives us a fair bit of guidance around how to have those conversations, how to treat that person when their time comes, and to advise families that we're trying to sort of support the individual here who no longer seems to have a voice at the table. So it's trying to recognise that person within.